going on, everybody? This is Lady Luck. All right, welcome back to Lady Luck Club with Sweet Tea. Thank you guys so much for tuning in. We have updates on Tyrone Davis Jr., young man that lost his life around Christmas time while out on a Christmas vacation with his girlfriend, Kiera, known as Lulu. So the Gainesville Police Department has concluded that the death was accidental, which is what they initially stated, that the manner of death was going to be. It just kind of confirms they had no intentions of doing any type of thorough investigation at all. This entire time, they've been saying, there's an open investigation. We're looking into it. That's kind of just slang for saying, we've already made up our minds and we're not doing anything. So the fact that they did not talk to witnesses and did not go out, gather evidence, it's a telltale sign that they were not investigating. And the worst part is, those who were trying to get information, FOIA requests for police body camera footage, all those things, were being told that they, could not release it because of this open investigation, which is supposed to be only said if you're doing it in good faith. If you're not investigating in good faith in hopes of, some criminal charges being brought about, or at the very least have evidence to support how any of this is an accident. And that's the one key piece that, I hope the family recognizes the Gainesville Police Department can be held responsible and accountable for. It's the fact that they don't have any evidence to support how this is an accident. We have not seen any traffic camera footage. There's no test results, no, results of them processing any car. You've had various stories given to 911 operators, various stories told to the family from the girlfriend, nothing. And of course, the autopsy report and medical examination are typically protected by HIPAA. So unless the family puts it out there, it's not something you'll be able to get your hands on. You would have to go to the next of kin to get permission because it is protected. It's medical information. Now, what they've provided, of course, in any, death like that, death period is the manner and cause of the death. But for them to just rule this as an accident and they have no evidence to support it, the family at this point needs to sue Gainesville Police Department and the city of Gainesville. And when I say sue them both separately. So you're suing the city, for their negligence and not ensuring that a thorough investigation was done. And then you're suing the police department for not conducting an investigation and for negligence and for failing to provide evidence to corroborate their so-called manner of death. There is a way to have a legal challenge brought about. The family is going to have to just do that. I understand they want to get a PI. But I think the money that they spend on a PI will actually be better spent on getting an attorney and suing them. And then all of the evidence that you want, or at the very least, what you can hold the city and the police department accountable for, can be either presented as discovery through a lawsuit, or you can have the police department, the officers, 911 operators, all these persons that were involved between the city and the police department subpoenaed to come in and testify. Hell, you can have the officers on the scene be deposed. A deposition will get you a lot more information because now they're being forced to answer questions under oath. And if they value their job and their credibility, they will not get up there and perjure themselves, even though police officers are known to do that. But it's this sloppy work from Gainesville Police Department that causes the public to not have any trust in the police department overall. So the legal justice system here is not perfect, but there are other ways to get their attention. And a lawsuit would do just that, for wrongful death, for negligence, and failure to conduct a thorough investigation for them to fulfill their duties, basically. That is part of their job. And for them to just show such a lack of, lack of sense of urgency and just a lack of interest in actually, performing the duties that they sworn under oath to do. It's something that you can hold them liable for. So that's what the family should do at this point. And I can guarantee you the city and the police department would probably rather settle, because it will bring to light how sloppy the Gainesville Police Department was. So I would push for that. Push for that. Get them deposed. Get these officers under deposition and make this happen. Because otherwise, this is where you are. You still can't tell his children what occurred, because there's no evidence to corroborate this being an accident either. They can't even take us through the travel path that was allegedly taken by the girlfriend, that led up to him, being somehow laid out in the middle of the street underneath a busy highway, underneath a bypass where you have cameras and businesses, traffic, witnesses that are all around. The failure of the police department to not even interrogate witnesses was the telltale sign they were not doing a damn thing. That it's sad to say that, but that was the key indicator. They're not investigating. They're not even calling witnesses in. You can't make this up. So unless they can provide evidence to prove that it was an accident, there's always an opportunity for a legal challenge. So the family needs to take the opportunity to go ahead and pursue a lawsuit before the timely filing limit expires, and hold the city and the police department, as two separate entities, meaning those two co-defendants should be named in your lawsuit complaint. Hold them accountable. This is the only way they learn their lesson. Sue them and hit them in the pockets hard for millions. You can't make this up. So shout out to, this is the True Crime Unraveled. I love these videos. I did leave a comment asking if I can just use portions of this, because there, of course, is a segment in here where Polo, who is one who had been looking into this, speaks in the, midway through. So shout out to True Crime Unraveled. Great work on your videos, and let's get to it.
This came forward describing laughter and screams. After a family begged for answers, the police has made its decision. The death of Tyrone Davis Jr. has been ruled an accident. Not a criminal investigation. Not a homicide. Not even a reckless endangerment charge. Accident. Case closed. Move along. Let that sink in. A man was found dead under a bridge. The last person with him gave 3 different stories. Witnesses say there were 4 people in that car. Witnesses say they heard him scream. Witnesses say he was pushed. And the state's official response? Accident. What message is Florida sending to its citizens? That if you commit murder, all you need is a coordinated story and a slow investigation? That if the system fails to do its job from day one, they'll just call it an accident and call it a day? Before we go on, this is True Crime Unraveled, and we have a lot to unpack. To everyone watching on YouTube, Facebook, and TikTok, we see you. We read every comment, every theory, every time you tag a friend. Keep it coming. And to those of you sending super thanks on YouTube, we appreciate you. You keep this channel going. You keep these stories alive. Thank you. Now let's get into what this ruling really means. Polo on his Facebook broke it down in terms anyone can understand. The medical examiner, they work with the city. They ruled what they ruled because they had no choice. They couldn't give it a different ruling. To give it another ruling is to open up a lawsuit for the city. Think about that. The medical examiner's office isn't some independent body seeking truth. They're connected to the city. They're part of the same system.
So the lawsuit is going to come either way. It's either going to come from them, having some sort of conflict. I don't imagine the police department suing the medical examiner. If anything, they'll try to just get rid of the medical examiner. But I don't foresee how, one entity can sue, the medical examiner who works for the city, because the cause and manner of death is not matching in accordance to what the police want. There is, precedence to where the medical examiner, can always provide a challenge to the police department when it comes to the manner of death. And if there's medical records, you have a medical examination that shows the contrary to what the police are saying. They don't have to be forced to coerced or persuaded to line up with the police department. Now, if there's like bullying and hostility going on, of course, it's corruption. That would explain why they would want to force the medical examiner, the ME, to present documentation in a way to where it lines up with this manner of death. But they're not obligated to be in sync with the police department. The ME, that's not their role or duty. Their job is to perform the examination and to outline, based on what is discovered in the examination, any testing that's done, and perform any diagnostics. They're just there to outline the facts. If the body shows that there's no way this was done by a car accident or a car hitting a person, based on the injury and the severity of the injury, the locations of these injuries, how many injuries are actually on the body. If the only injury is blunt force trauma to the back of the head, they give their expertise, because They went to medical school. This is what they do. They have the right, in their expertise to challenge the manner of death. If the police want to put down an accident, no one cares. That's the issue here. So if the police department gets sued out of their asses, that's exactly what should happen. So is GPD going to sue the ME? No, but the family can sue them. So either way, they risk taking a lawsuit. I think they're just kind of hoping that the family does not sue. I think that's what this is coming down to. It's the cockiness and the arrogance of GPD to have this, mindset, I guess, to think that the family will not sue them or challenge them. That's very possible. It happens all the time. There is plenty of precedents to show where you've had an embattled or a troubled or corrupt ME and or police department to just completely ignore, examinations, doing any investigation on a death this suspicious that has gotten this much attention. And it gets sued and they lose. It's not a rarity. This is very common. And I can literally present cases, and I will do that in the next video. Show you all a few other cases and other precedents that's been set where you've had the same scenario of the ME and the police department not seeing eye to eye on the manner of death. And it turns out to where one is doing their job and due diligence and the other one does not want to. And one is forcing the other to agree with them just to cover it all up. And in the end, those people get exactly what comes to them. Sometimes they work together and they're both corrupt. So the family should not care if the ME and the police department aren't, lining up and somehow something's going to happen with a lawsuit. No, the police should be afraid of the family suing the hell out of them. So who cares if the police aren't happy? Their job is to investigate, protect and serve, and uphold the law. That's it. Not sit here and coerce the ME to put something down on paper. And then guess what? These documents are legal documents. They can also be used against them in a court of law. It would not behoove the ME to lie like hell. So if the medical examiner had to forge or fudge information or lie, those statements you make on that medical examination, you are making them under the penalty of perjury. You are saying that you are attesting and affirming that the examination was done thoroughly and appropriately in accordance with the law, rules, regulations, and that everything you notated on here as the medical examiner is true and accurate. If it's not true and accurate because they're afraid of what the police department will say, because no one gives a crap about the police department's thoughts or feelings in this. It's not about their emotions. It's about the facts. It's about the law. It's about evidence. But if they're sitting here intentionally falsifying information on the medical report, the family definitely has a lawsuit. So now you have just yet another added complaint to a lawsuit where you believe that the information on the medical exam, on the police reports are not truthful or accurate or factually based, and it was intentionally forged. They intentionally gave false statements on these documents. Use it against them in the court of law. It's that at this point, that's the only best option you can have. And go from there. Let the evidence in a lawsuit take you where it needs to go. Get these people deposed. Get them under oath. Get the discovery. That's the best route. And if you still want to get a PI, great. But I can guarantee you, even after the PI gets all this information, then what do you do with it? Other than release it to the public to say, yeah, look, see, they weren't doing shit anyway. Well, we know that. But you gotta take that next step. So once you get this information, what do you do with it? Because the only option the family would be able to take if the PI discovers in their investigation, if this private investigation comes across evidence where, it looks like the police lied, the ME lied, people are covering up for each other, all this stuff, and it doesn't match, an accident, guess what? Let's say you get that information and the private investigator types out a formal recommendation for charges, and you take that to the prosecutor or the DA. Then what? If they don't bring forth the charges, now you have a real problem. So pursuing criminal charges is not the only option you have. You can also go the civil route and just sue them. That lawsuit will be a civil procedure, but it would not be hard to meet a burden of a preponderance of the evidence if you have sufficient evidence to prove that it was more likely than not that the city is negligent, the police department, hell, add the ME if you want. And they falsified information They failed to do a thorough investigation. They failed to provide evidence leading to negligence, leading to them falsifying these reports and exams. You have that route you can take where the burden is not so stringent as it would be in a criminal matter. For a criminal matter, the burden is to prove beyond a reasonable doubt. In a civil matter, the burden is a preponderance of the evidence. You just need to be 51% convincing. That's it. That's what it comes down to. And even if you file a lawsuit in a civil procedure, you can also file for a jury demand. So you can still have a jury trial in a civil matter. So this is why I firmly believe that the family needs to file this lawsuit. They literally have nothing to lose at this rate. They have nothing to lose but time if they wait. If you wait, you run out of time. And you get, by law, a certain amount of time to file the lawsuit. So the only thing they have to lose is time. Other than that, you have nothing to lose. File a lawsuit against them.
And if they rule a death a criminal matter when the police already botched the investigation, they're essentially admitting the city failed. To change it from an accident to a criminal investigation is a door. It's a door to open up a guaranteed lawsuit. The city would have no choice but to settle because they never did investigation. They never pulled camera footage. When they said it was an ongoing investigation, they lied. They never did nothing. So the ruling isn't about evidence. It's about liability. It's about protecting the city from paying out millions in a wrongful death lawsuit. It's about covering tracks. To give that paperwork another ruling beside what was already put on them is suicide for the city. They had no choice. Suicide for the city. Not justice for Dro. Not accountability for whoever was in that car. Just protecting the budget.
But let me tell you something else. They didn't rule it accident or whatever because that's what they felt like it was. You know what I mean? The medical examiner, they work with the city. They ruled what they ruled because they had no choice. They couldn't give it a different ruling. To give it another ruling is to open up a lawsuit for the city. The ME work with the city. They can't just do that. But if enough pressure was applied, then they would be forced to make that decision. But being the fact that enough pressure wasn't applied, they didn't feel like they were obligated to change that ruling. But if you pay attention to every time pressure is applied, that ruling get changed. But being the fact that
well, it comes down to evidence. That's what it comes down to. If there's sufficient evidence to prove that whatever the police and the ME put on their reports and they're sitting out here, trying to proclaim it being accidental, but evidence shows that it was not accidental, you can challenge that in court. You can take that case, if you want to try to see if there is a path to criminal charges being filed. Well, criminal charges are filed to the court from the prosecutor. The police does not take the charges to the court. The prosecutor does. So whether it be the attorney general for the state or the district attorney for that district in Gainesville, whatever court falls within that district attorney, also the prosecutor, are the ones that actually brings forth the charges to the court representing the state of Florida. So in turn, they will be representing the victim. So it'll be like state of Florida versus whomever is charged. But that's something that the prosecutor does. So if you can provide, if a PI or let's say the civil lawsuit, from the civil lawsuit, you have enough evidence to recommend that criminal charges be filed, you can use that civil lawsuit and all the findings from that civil lawsuit to also present to the prosecutor to say, your police department are a bunch of bums. The ME may or may not have been pressured, who knows? No investigation was done, but look what happened as a result of this civil proceeding. And that happens as well. It's very possible for criminal charges to come forth from a civil lawsuit because this process of gathering evidence is no different. The only difference is the burden you have to meet in court. You can still do depositions. You can still have a jury trial. You can still get evidence through discovery. You can still have people depose. You can put people on the oath and have people subpoena to testify. It's no different. So once you gather evidence, and let's say they file a lawsuit and they win, the family wins, and the evidence points towards, at the very least, negligence. The police department can be charged with that as well. Whomever spearheaded the investigation can be charged with negligence. The ME can be charged with falsifying the medical report. So from the civil lawsuit, you can also get criminal charges brought out of that, and you will have the evidence to support it. That's the difference here. So the city and the police department, the medical examiner, name all their asses in the lawsuit, and then go from there. And then if the family still wants the PI can also be working in tangent with a civil proceeding. But they need to sue them because that's the best route, because you get this evidence, whatever comes out from the PI, then what? You end up in the same place either way. But having a civil proceeding and you win that lawsuit, or they decide to settle, Don't sit here and say we're not going to hold the city accountable. No, hold them accountable. At the very least, force them to go to jury trial. We're not going to take a settlement. We want you all in court because we want you all to be interrogated. We want testimony under oath. We want these depositions. We want the discovery because that is going to help build up whatever criminal case can come out of that. Whatever criminal charges can come out of that is going to build that case up, almost in sync with the civil proceeding. So let it happen. Sue them.
Side of the family didn't put boots on the ground and apply full court pressure like they should have. That's why they didn't change it from what it was. To change it from an accident to a motherfucking criminal investigation is a door. It's a fucking door to open up a guaranteed lawsuit. The city would not win. The city would have no choice but to settle because they never did investigation. They never did pull the camera footage.
Still
When they said
face
it was
the
an
same
ongoing investigation,
issue.
they lied. They never did nothing. So to give that paperwork another ruling beside what was already put on them is suicide for the city. It's suicide. It's suicide.
Two is no one should care about.
That's why the Davis family should have paid and still can pay for their own autopsy report. They can pay for a private autopsy report. They don't have to go by what the city gave out. They didn't have to go by what the ME gave out. They were connected to the city. They could have got their own private autopsy report done privately. There's so many things that you can do outside the city, but you got to pay for that. You got to pay for that. We all know. Let me tell you something. We all know that. I mean, if you're not satisfied with the autopsy report, then you pay for your own. If you feel like foul play took place, then you pay for your own autopsy report. You go get your own medical examiner or your own people to do it. You pay outside people to get it done. Outside people get it done. That's just like, oh, that's talking about, oh man, listen, man, everybody lie. The judge lie, the state lie, the prosecutor lie, the people in the jury lie. They know you're innocent, but they still say you were guilty. In this world, bro, in this world, you'll learn when it comes to the city and it comes to the government. Sometimes they gotta lie, and sometimes they will lie. To prevent payment or any money being paid out to anybody, they will lie. This is a proven fight. These people lie every day.
That's part of that's part of the problem. He's not saying anything factually incorrect, but it's not an excuse. That would be my thoughts on that. It's not an excuse at all. I mean, the fact that it's common knowledge that the police department will lie like hell, is even more proof that you got to hold them accountable. Even if it means filing a lawsuit or, if you're going to spend out money, make sure it's well spent. That would be my personal thoughts and opinions on it. I can't tell the family what to do, but I think that, if you take the route of filing that lawsuit, all the things that Polo is saying, it's inevitable. They're going to be sued, and it's going to come out that they lied, that they schemed to try to, avoid doing a thorough investigation, and that they were highly negligent. They handled this case piss poor. That will come out either way. So, I'm hopefully he's just saying this because he wants to just drive his point home. But I think it's common knowledge, and it's stuff that people already know. I just put it like that. It's not anything wrong with what he's saying, but it's just I'm assuming he's trying to make the point that you got to hold them accountable because they lie like hell. Hopefully that's what he's saying right here.
But when you apply enough pressure, they have no choice but to give it a different ruling. If you pay attention to the history of Florida, the state of Florida move a certain way. Anytime you come at anything humble in the state of Florida, you would not get no justice. In the state of Florida, anytime you approach any situation when it can revolve your family, especially of the minority in the state of Florida, anytime you come humble, you would get no answers. You would get no justice. Every time pressure was applied in the state of Florida, they got results. They got results. If this would have happened in Polk County, Grady would have had Lulu ass in the jailhouse. If it would happen in Daytona, they would have had your ass in the jailhouse. If it happened in certain counties, it would have never slid. It would have never passed. It would have never passed. They would have been, Grady would have been sitting right there with a gold chain on, getting a press review. Laying that shit out. Because Grady ain't no fool. He ain't going for it. He don't give a fuck what color you is. Daytona Beach, the goddamn chef, Chipman, whatever the fucking name is, he ain't going for it. He ain't going for it. Certain areas they ain't going for it, bitch. You're going to jail until further notice, and that's just what it is.
And here's where Polo didn't hold back. He pointed out what the Davis family should have done from the beginning. And let's talk about something else that makes no sense. Even if we take the police report at face value, even if we ignore the witnesses, ignore the screams, ignore the 4 people in that car, their own ruling doesn't hold up. Polo pointed out something that should be obvious, but somehow got lost in all the noise. If I jumped out of the car, it wouldn't be an accident. It would be suicide. If I jumped out the car, I committed suicide. I caused my own death. That's not an accident. Think about that. The police report says he jumped. Lulu's story says he jumped. But if he jumped, that means he intentionally exited that moving vehicle. That means he made a choice. And when you make a choice that ends your own life, that's not an accident. That's suicide. So even if we accept their version...
Yeah, right. Exactly. The manner of death should then be ruled as, self-termination. That's kind of where this is. It's like, if their life is taken by someone else, it would be a homicide. If they, of course, self-terminate it, then that would be ruled as this suits, word. Because YouTube is finicky, and they will block a video over, saying that word. But that's the truth of the matter. the manner of the death would have been ruled as a subterm, not as an accident. You don't accidentally, intentionally jump out of a car knowing that you're going to, if not be, terminated, you're definitely going to come out with some severe, serious injuries, especially if you get hit by a car. But they didn't even investigate that as a hit and run. If he was hit by a car, where's his other car? Where's the other driver? Where's the information about this vehicle? If he jumped out of a moving vehicle, and let's say no car hit him, there's a chance at 25 miles per hour, right? There's a chance that he could have survived that. If it's only moving at 25 miles per hour, you're going to be injured. But will you be, put in critical condition and to the point of death with some severe blunt force trauma to the back of the head only, and no other injuries that are, that correlate and align with the aspect of somebody jumping out of a car? You're going to have more injuries than just blunt force trauma to the back of the head. But let's say he, decided to just get out of the car on his own, and he was not hit by another car. Then the injuries you expect to see would be more of, maybe a couple broken bones or some bruising. If he hit his head, what did he hit it on? He's not going to get out of the car head first and just land only on the back of the head. That's not something you just accidentally do. And we're talking about this one injury that we know of that has basically coming from the physician. That has been the main, talking point, the main question that everybody has. How do you jump out of a car and only incur an injury that the doctors described to be blunt force trauma to the back of the head, to the extent where skull bone pieces move from the back to the front of the head, all by just jumping out of a car that's going 25 miles an hour, and no vehicle hit him? Because if a vehicle hit him, the police department is still negligent. They should still be held legally liable, because that means they failed to investigate it as a hit and run, because we have no information about the other car and about the other driver. And if the girlfriend hit him with a car, why is she not in jail for hitting somebody with a car? How would he be able to jump out of a car and get hit by a car that she's driving if he's the driver? It just doesn't make sense. He jumped out of the car and the car was moving at 25 miles per hour, according to her statement, not according to the police, not based on evidence of any sort. And yet they did not investigate that as a hit and run, because she still left the scene. She should have stayed there. If she hit him with the car, let's go with this for a second. Hypothetically, based on what she has said, if Kiara hit him with the car and she still left the scene of the crime, that still should have been investigated as a hit and run. Legally, that's exactly what she did. She hit a person with a vehicle that she was driving and operating, and she did not stay at the scene of the crime where he was hit. She drove to a gas station away from the scene of the crime and failed to call 911. She failed to report she just hit someone with a car. And if she was at the Circle K gas station, he jumps out of a car, and she didn't know whether or not he got hit by a car, why didn't she walk back to the bypass immediately after pulling into the gas station to go check on him and make sure he was okay? It's the actions of the things that she failed to do that are more problematic and absolutely gross and disgusting than it was with her coming back, ironically, with the paramedics being there, even though the gas station is in eye view of that bypass. But she goes to the gas station and does not return back to the scene of the crime, nor does she call 911, nor does she report she just hit somebody with a car. Once again, the police failed to outline with evidence how it's possible for someone to jump out of a car and the only injury occurred is blunt force trauma to the back of the head, as the doctors described it to be, as diagnostics will probably support. I'm sure they did an MRI or a CAT scan, because they would have had to examine him. They would have to know what the extent of the damage is. For them to know that skull fracture pieces move from the back to the front of the head, they definitely had to perform a diagnostic test, whether it be a CAT scan or an MRI. So you already have diagnostic test results that you can utilize to help you with your lawsuit. And then you can challenge what the police department ruled as manner of death and the medical examiner utilizing those medical records of the diagnostics reflecting blunt force trauma to the head. And then you can force them to answer, how do you get that type of injury jumping out of a car? And let's say a car did not hit him. How does that happen? What evidence do you have to prove that this was purely accidental and not his attempt to end his own life? And if that be the case, like True Crime is saying here, then why was that not listed as manner of death as the suicide, as self-term? Why? That is a manner of death. They could have put that on the report, but they didn't. So you already have a discrepancy. So the family can take the discrepancy that's obvious and sue them. This isn't about, like, the police department are really dumb. This isn't about, oh, they're trying to avoid a lawsuit. No, they already opened themselves up to a lawsuit because they have not presented a case and any evidence where it's even remotely convincing that he willfully jumped out of a car, wanted to terminate his life, but yet the police report, the medical exam, the autopsy does not list manner of death as suicide, as self-term. But that's exactly what, based on what they're saying, it should have been listed as. So either way, listing it as accidental is a clear discrepancy off the rip. So it doesn't match. And diagnostic test results do not lie. If the CAT scan or the MRI was done, in order for the doctors to see these skull fragments in the front where they don't belong, that is not accidental. Now you have to explain the injuries, and it has to be supported with evidence. The timeline has to make sense. We don't even know what the full timeline is here because they put out so many mixed stories and messages. It's just ridiculous. But this is, to me, it's still very easy and clear to see that they already have enough discrepancies that has been put out to the public between the doctor, the physicians, the medical examiner, diagnostic test results to utilize to say that the police department still failed to investigate, to gather evidence, to even conclude that he jumped out of the car, but it was an accident that he jumped out the car. That defies all logic. And the worst part is the police department thinks that we're all stupid, as they are. It's an insult to our intelligence, and it lacks logic and common sense. And if this went to court, the judge and the jury would definitely apply logic and common sense and use wisdom in that lawsuit to be able to determine, okay, we have sufficient evidence showing one scenario where blunt force trauma to the back of the head, the extent of the damage with the skull, is not being explained by the police department with evidence as to how that occurred. So was he hit with a car or not? Because that's a hit and run. That's not him jumping out of a car. If she hit him with a car, hit and run. She should have stayed at the accident, the scene of the crime, and called 911. So she failed to seek medical help after hitting someone with a vehicle. And I don't know about anyone else, but there's a sound, a thud that's made. Let's say if another car hit him, you're going to hear a thud sound. It might not be as resonating if it were two cars crashing into each other. But if somebody gets hit by a car, it usually makes a hard thud sound. It's going to be like a boom. It's still something audible that you can hear. And that's not something people will not, like, you got plenty of witnesses that says otherwise. These are the same witnesses that the family can ask to come to court to testify if they sue the city and the police department and the medical examiner, though. That would be the family's opportunity to have these people subpoenaed or however, if they willfully decide to testify, even better. And I'm sure if they want to help with this investigation or with trying to get justice for this young man, that they will be more than happy to testify. That can also be done in a civil matter. So sue them. Sue them, for the love of God, sue them.
Events, the version that contradicts witnesses, contradicts physics, contradicts common sense, they still got it wrong. They can't even rule their own story correctly. This isn't an accident. It never was. It's either a crime or a suicide. And since everyone who knew Tyrone says he had no reason to take his own life, since he was fighting to get back in that car according to witnesses, since he was hollering and trying to survive, the only logical conclusion is the one they refuse to make. This was a crime. And by ruling it an accident, the state isn't just protecting itself from a lawsuit. They're gaslighting a family into believing their son's death was something it clearly wasn't.
Can't make
That's all
this
she was
up.
saying. But let me educate you on something. They didn't rule. Let me tell you something. If I jumped out of the car, it wouldn't be an accident. It would be suicide. If I jumped out of the car, it would be suicide. I committed suicide. Accident mean that's something I didn't do intentionally. If you say I jumped out the car on my own, then I committed suicide. Accident mean it didn't mean to happen. I didn't mean to do it. But if I jumped out, like you said, I jumped out the car, that's committed suicide. That's not an accident. Just like, you know what I mean, when little Papa died in Jacksonville, it wasn't ruled an accident. He caused his own death. It was ruled a suicide.
The Davis family should have paid, and still can pay for their own autopsy report. They can pay for a private autopsy report. They don't have to go by what the city gave out. They could have got their own private autopsy report done privately. A private autopsy.
Yeah, I think that can be, and I don't want this video to be too long, so thank you all so much for checking out this video. Make sure you guys hit the like button so we can get this video up there in the algorithm so that somebody will watch this and get it back to the family. They can easily pull whatever reports are available online. Like I said, there's precedents to show where you have the ME not agreeing with the police on the manner of death, you know, and it was legally challenged in court. You have so many case law, so much case law you can utilize, you know, to show that this is not something rare. This, unfortunately, is just all too common. And if the manner of death should be him self-terminating, then it would be listed as that. And there are other medical reports that can be shown as examples, you know, to the court to support that this could have been named as a self-term. It's that simple. The police is making this way more complicated than it should be because of their failure and their lack of willingness to actually do their job. So the family needs to sue. That's what this comes down to. And I hope somebody gets this to the family members that are, you know, truly seeking justice. The mother is sitting here saying that she's received some threats of some sort. I want to see if I can pull that video and touch on that, but in the next one. But she called and recorded the call with the medical examiner trying to confirm in the call that this was, you know, ruled as an accident. Let me see if I can pull that right quick. Okay, this is just the first video I was able to grab from Shanitra Speaks. Make sure you guys go check her out. This is just a YouTube short of the mother calling the ME, I guess, to try to, you know, confirm. And she recorded a call to confirm the manner of death. She recorded the call, did not tell the ME that they were being recorded, and then she put it out on the public platform. I don't know if Florida is a one-party consent state or not, but she should have told the ME that the call was being recorded. And I can guarantee you, the ME would not have stayed on that phone. So this is just ridiculous. But let's check this out.
Yes, I just wanted to make sure because I got another phone call because I've been getting a lot of threats about Tyrone's death. Mm-hmm. And I just wanted to make sure on my behalf that it was an accident. It wasn't no foul play.
Correct.
No foul play. It was an accident. Correct.
Correct. That is correct.
Because they're saying that I killed my son.
Oh.
Okay, let me correct. This is the enforcement official. Allegedly. Who knows? I mean, this is the horrible, you know, aspect to this. When you're sitting here calling somebody and recording a call like this, where they're confirming this type of information, we have no way of knowing if she's truly talking to some law enforcement official. We can't see them. There's no documentation going along with this. She would have been better off getting something in writing, but she didn't. Or going to the police station and doing a live stream and recording herself talking to the actual law enforcement official. But she didn't do that either. She called somebody, God knows who this is, and then asked these questions. It could have been, you know, one of her relatives or something. Who knows who we're listening to may not be law enforcement official. And that's the finicky part about doing stuff like this. When you're recording a call, there's no video to go along with it. We have no idea what this person's name is. And then you're saying that you're speaking with law enforcement. We don't have to trust that. We don't have to believe that. And at this point, she should not be offended if people don't believe what the hell she says. Or whatever this person on the other line is saying. Because when you've had the father side of the family received 3 and 4 versions of what happened, the mother didn't even want them to know. She told one of his friends, you know, who went to the hospital, that Jason Johnson, somebody, not to tell anybody It's like, okay, I don't put it past her to have someone be on the other end of a phone call just saying what she wants them to say, and we can't verify this person to be a member of law enforcement that actually oversaw the investigation. Why would she not go to the police station? You can record at the police station in the public area and then ask the investigator to come out and say, I have a couple questions. I would like to be able to record the responses for just, having an official record here. Can you confirm XYZ ABC? What evidence do you have to support that? Because I'm allegedly getting, threats and all this other stuff. Why not go and record them at the police station? That way we can see visual. Ask for some evidence to support this was an accident. Why not at least put that out there? If you're going to do stuff like this, ask the police officer, the investigator, to produce evidence to prove that it was accidental. Just someone saying, no, it's not accidental. Well, no one is obligated to believe that crap. It's nonsense. So whoever this woman is on the phone could be a cousin. I mean, who knows? But the bottom line is we still have no evidence to prove that it was an accident either. So you would think the mother would at least ask for that and then put it out there. Don't you think if she really wanted to clear her name? Because this, once again, is logic and common sense. If she was truly trying to clear her name and she had evidence from the investigators to prove that this was an accident, don't you all think she would be showing that evidence? She went to a town hall meeting of some sort, showed her ass like a country bumpkin, decided to record somebody on the phone saying something. And yet, you don't take it upon yourself to ask them to provide evidence to prove this was an accident. Make it make sense? That would be her opportunity to gloat. See, you all, here's some evidence from the investigator of an investigation that was done, proving that this was an accident. Here you go. Here's all the evidence. I mean, why would she not take the opportunity to show us the evidence? Show us the proof. I think that's what most people are expecting to see at this point. Prove that it was an accident. Show the evidence. Why make this phone call, but not go to the police station in person and record the person, the investigator, showing you evidence step by step as to how they arrived at the conclusion of this being an accident? Why not go all the way there? You can't make this up.
No, absolutely. That is not. No, it was ruled an accident, so absolutely no.
Hey,
we have no idea of knowing if that be the case because we have no idea to verify who this person is. And she's not saying much. We don't know her name. We know nothing. This is so pathetic. It's not even funny. And the father side of the family, hopefully they do consider filing a lawsuit, can use this call as evidence to prove that you have this campaign of this false perception of this being ruled as an accident with zero evidence whatsoever. Zero. So you can't say, oh, we didn't mean to lie like hell to the public. No, this is intentional. The mother intentionally called this person, intentionally recorded this person, failed to seek permission. If this is a member of law enforcement, they failed to provide evidence to prove it. This is so sloppy, it's ridiculous. And she's supposed to be a mother. You can't make this stuff up. So this is the latest scoop on this. And hopefully, like I said, the father side and any other relatives. I do believe there's some people on the mother side that do want, questions answered. They want evidence. They are, saying that the girlfriend has a lot to do with this and demanding that she come forward and tell the truth. I say this, and it's because this is a history and pattern of cases like this. Money can be one hell of a motivator, not just for the ones wanting this to stay under wraps, but for those that it could possibly be giving money to as a form of bribery so that they can just throw this under the rug, rule it as an accident, but then claim that he wanted to self-term, but not want to put that on the autopsy report. You can't make this up. So push for that lawsuit. That's your best bet. In all these videos, posts, the girlfriend has done, use it against them in a court of law. Have their asses subpoenaed to come in and testify. Get them deposed. As a matter of fact, get all the people that were there at the hospital to come in and do a deposition, to come in and testify. The witnesses, that's a perfect opportunity. Get the lawsuit done. It's that simple. All right, y'all. Thank y'all so much. I hope this does get to Natasha, the father side of the family. Any relative that truly wants justice, I hope they hear this, because this is just beyond imaginable at this point. The mother is absolutely disgraceful. This was a pathetic attempt to sit here to try to clear your name, but yet you're not concerned about why they came to this conclusion, nor are you interested in trying to get evidence of your own son's death that the police is saying, yes, this is an accident and there was no foul play. You can't make this up, but you don't want to challenge the actual diagnostics that will prove otherwise. The mother is absolutely despicable. All right, y'all. Hit the like button. Leave your comments and thoughts below. Let me know what you all think about this. And until the next one, Lady Luck Club out.